Thanks to everybody for joining us today. The reason for this roundtable discussion is that, of course, we are still dealing with the COVID-19 crisis, and all over the world, businesses want to know how they can keep employees safe and how they can avoid lawsuits and complaints from anything happening in the workplace related to COVID-19. So today we have brought together Mackrell International law firm lawyers from 5 jurisdictions, and they're going to help us talk about these issues. And we are going to do a kind of a roundtable format, question and answer, and get perspectives from 5 different jurisdictions. And I'll be asking questions, and I have a list of questions, but if those of you who are attendees, if you have questions that you would like us to address, you can use the chat box, and I see that some of you have already found that, and we will try to work your questions into our discussion. We will go until 12 o'clock, and I have a hard stop at 12:05 here in the Eastern time zone, but we're looking forward to a productive hour. And so the first question I'm going to ask our panelists, and let me say to our panelists, I will ask, once I ask my first question, before you answer, if you don't mind taking 30 minutes to tell our audience who you are, where you're from, and what area of employment law you practice in. That would be great. And Timm, I will start with you. Can you tell us, Timm, what kind of claims have been brought in your jurisdiction, which is the United States in general, I believe Missouri in particular, over COVID-19 related decisions that employers have made?
Sure. Good morning, everybody. My name is Timm Schowalter. I'm a labor and employment attorney in St. Louis, Missouri, and I've been practicing labor and employment law for 25 years and do the panoply of all labor and employment cases and the various laws. What we're seeing here in the United States is from a plaintiff's perspective, is there are certain cases dealing with paid time off under the Fair Labor Standards Act, as well as obviously the FMLA implications. And we're starting now to see trickle in some of the issues associated under the discrimination lawsuits under Title VII with respect to the initial layoffs, as well as with now the certain companies are bringing people back. Not a lot, but certain companies are. That's on the civil side. On the government side, the Department of Labor, OHSA, has been very active and running around doing inspections, and especially in the healthcare industry, and ensuring that they are utilizing proper respirators, proper training, and the like. So we've seen most of the activity that I have personally witnessed is more on the OHSA front and defending companies in OHSA investigations, especially if you have a nursing home care or a patient that has it, or then unfortunately if you have an employee that has deceased due to COVID, OHSA will be at the doorstep really quickly.
Thank you, Timm. Laura, let's move to you in Canada. What kind of claims are you seeing brought against employers these days related to COVID?
Thanks, David. I've been with Scott Pinchero Rudicoff for 10 years now, and have an employment practice that has become quite busy in the last year in particular. Somewhat similar to Timm's comments, we've been seeing in Canada one of the more high-profile big lawsuits was in the summer, where class action was filed by employees at Cargill, a meat packing processing plant, saying that their employer had failed to take reasonable steps to make the work safe for their employees. And I think there was about 500 cases associated with that. So that'll be moving through the courts. Just last week in Calgary, it's not specifically against an employer, but a restaurant in Calgary where there was an outbreak linked to that. There was a proposed class action for close to $20 million for people who became ill dining at that restaurant. And then we've also been seeing claims for wrongful dismissal for people who've been laid off, where their contracts don't provide for layoff provisions, and constructive dismissal type claims where compensation has been cut back drastically. And then we've also seen claims starting for people who have made disability claims, who are sort of the long haul sufferers of COVID, and that's been denied. And it's an open question as to whether sort of a long haul COVID is a disability for disability benefits.
Thank you, Laura. Ulrike, let's move to Germany next.
Thank you. My name is Ulrike Dörrie. I'm working in the employment law department of SLB Kloepper in Munich. And now I think court cases that are related to COVID are picking up in labor courts, and they are dealing mainly with certain aspects of COVID, working under COVID conditions. So it's continued payment of claims for continued payment of wages during not quarantine, but so-called time at home in order to wait for a negative testing. Then there is this discussion of whether the employer is allowed to shorten the vacation entitlement during short time zero, which is also probably familiar to my colleague from Sweden, since that is a European court ruling which they refer to. Then it's the short time as such, the arrangements coming with short time. What is becoming more and more apparent is the recourse that is taken by the employment agency on payments for short-time work, because it was unlawful to claim for short-time payments by some employers. And then there's nitty-bitty bits which are probably ending up in some employment laws, whether there is a right to work from home and whether employees can request to work permanently at home or from home. So that is slowly developing, and now the cases are picking up where dismissal are challenged because after 1.25 years of short time, there's an increasing number of companies that don't survive with this large number of employees. So the dismissals have picked up, and now we're seeing them being challenged.
Thank you, Ulrike. Jessica, Ulrike just referred to Sweden. Tell us, what is the situation in Sweden?
Well, the situation would be almost the same as in Germany, I would say. My name is Jessica Stålhammar, and I work in a law firm called WSA in Sweden. And I've been working with labor law for 20 plus years. And as I said, the disputes are closed ones in Germany. We have a law called the short-time work allowance, which makes it easier for people to go home, and the government, the state, pays part of the salary for employees. And there have been many disputes along the way, how to calculate the hours, earned vacation and such. And also we have disputes concerning redundancy. We've had many redundancy situations, of course, throughout Sweden, and we think we will have even more within shortly. And of course, then due to that, we also have more disputes around that.
Okay, thank you, Jessica. Girija, let's turn to India now, please.
Hi, thank you, David. This is Girija Balakrishnan. I'm from Malvi, Ranchoddas in Mumbai. My core area of practice is corporate and commercial, but as a part of that, we have been advising clients on employment law issues. And over the last 1 year, there have been several of these issues where we've been constantly engaging with our clients and advising them on compliances and on potential litigation matters. So in India, basically, we have a federal form of government where both the central government and the state governments can formulate laws relating to employees and workmen. So at the central level, we have something called a Disaster Management Act, which required the employers to make payment of full wages to all employees, irrespective of whether they have been able to come to work or whether they've been able to work from home. The second part of the central law also required that the employees' services should not be terminated. So as can be imagined, there have been several litigations by the employers with reference to their right to terminate in case of redundancy, in case of having to follow other employment related laws for termination. Whereas from an employee perspective, they have been seeking strict implementation of the central legislation, which requires complete payment of wages to them and also a right against termination. At the state level, we've had a more pro-employer kind of legislations that many states have opted for. So where they have increased the hours of working, both in terms of daily and on a weekly basis. And they have also sought to rationalize the payments that are to be made to the employees, depending on whether they have been able to be employed gainfully or not. So there have been litigations at the state level challenging these state acts where the state government has sought to amend laws with reference to their terms of employment or requiring them to put in additional hours of work. And this mainly was because several of the migrant laborers on whom most of the industries depend in India were making a beeline for their own home states. And therefore, there was a shortage of skilled labor in many sectors and many industries, which required these kind of legislations at the state level. So these are broadly the kind of problems that we are presently facing in India. And several litigations are pending in the High Courts and in the Supreme Court on these.
Thank you. That's very interesting. Let's move now to another question. And Timm, we'll start with you again on this one. Would each of you tell us in your jurisdiction, is it permissible for employers to require employees to take a COVID test before they return to the workplace?
Generally, yes. I will start off with the overall premise that in most states, all employees in the United States are typically an at-will employee, which means that their employment is consensual both from the employer and the employee side, meaning they can be let go for any reason at any time. So that allows the employers to set the terms, conditions of employment. Obviously, there's an exception if there's an employment contract that dictates the terms, but generally, an employer can set the terms, conditions of employment. So if in fact the employer wants to impose a policy that you must get tested, then they have the right to do that. Now, there are, I'm sure there'll be some questions later on in the day about the same issue with vaccines, but there are some exceptions to the general rule, obviously. regarding typically health-related concerns, truly a disability-related concern, or some type of religious objection, a bona fide religious objection. But otherwise, employers can require, as a condition of their employment, to get tested and to take the necessary safety precautions.
Thank you, Tim. Laura, we'll move to you, and why don't you go ahead and do what Tim did, which was to answer both questions. Can you require employees to take the COVID test before coming to work? And can you require them to be vaccinated before they come back to work?
The first question's a little more straightforward. The second one a little more nuanced. But to the first question as to whether you can require employees to get a test before they come into the office or their workplace, I guess, the general answer is yes. And there was a recent decision in December of this year in Ontario where individuals who worked in a nursing home were objecting to mandatory COVID testing twice a week, and their union grieved, and ultimately the arbitrator dismissed that, saying that the policy was reasonable and weighed against the objective of preventing spread in retirement homes, which has been a huge problem, I think, across the world. But weighed against that is the privacy issues that are raised by some employees with respect to that. And in Canada, we have both federal and then at the provincial level privacy legislation that applies to collection of personal information from employees. So we've been advising employers who are requiring COVID testing, particularly, and it's not really controversial in any kind of healthcare settings or settings where you're in contact with vulnerable individuals, but to ensure the employees are comforted that you will take all measures to protect, their privacy and the COVID results and how long you keep them for and whether they're destroyed. And then with respect to whether you can require vaccinations, again, the answer is generally yes. However, if you want to have all your employees vaccinated in Canada, you have to show that it's a bona fide occupational requirement, so that there has to be a rational reason why everybody has to be vaccinated, and that will apply differently in different workplace contexts. And there's a test that you have to go through as to whether it's a bona fide occupational requirement. We have you have to establish that there's a reasonable connection and a legitimate interest in having everybody vaccinated. And we don't have any cases that have been decided yet, but looking to sort of decisions around mandatory influenza vaccinations in the workplace, give us, some indication of how arbitrators and courts might find, but generally we only find those in the healthcare context. And it's, if someone refuses to be vaccinated for, again, a health reason or a religious reason, they're excluded for the workplace, but only for the duration of an outbreak, and it's not a disciplinary kind of thing. So you have to accommodate the employee to the point of undue hardship. But in general, especially if it's a new employment relationship, it's got to be clear that as a term of employment that vaccination is key to that. And if it's going to be existing employees, again, it's going to depend on the nature of the workplace and whether you can justify mandatory vaccinations. But we don't have any cases yet in Canada that have decided on that issue.
Laura, in Canada, are employees able to claim any exemptions if their employer says, we want you to get vaccinated before you come back? Like in the United States, if somebody has a medical condition or a disability, we have a law called the Americans with Disabilities Act that may provide that the employer has to give them an exception. There's also an exception that is generally recognized by our government agency that administers the anti-discrimination laws for religious reasons, which doesn't come up very often, but it does come up. Does Canada recognize exceptions like that if an employer wants to have a mandatory policy?
Yes, and that ties into the bona fide occupational requirements. So our Supreme Court has said that if you're going to have what may be a discriminatory employment practice, say, a firefighter has to be able to carry a certain number of pounds, and women say, well, that discriminates against us. To show that it's a bona fide occupational requirement, it has to be rationally connected to the performance of the job. So again, in the healthcare kind of sector, that will usually be established, and it's been adopted in good faith and in an honest effort to fulfill the legitimate workplace purpose. And then finally, it has to actually be necessary for the legitimate workplace purpose. So what the court is looking for is for an employer to be able to say that it's impossible to accommodate that individual. For whatever reason, they can't have a vaccine or they have a conscientious objection, but you have to show that it's impossible to accommodate them otherwise. So a nurse who says, I can't be vaccinated and I work in the ICU, you can't have her work from home. But it's a pretty high standard, and seeking an exemption or seeking accommodation, employers, as a first step, you always want to consider whether you have a duty to accommodate and then how that might be done. And it's only once you've reached the point of undue hardship, really, that you have grounds to, sometimes it results in termination, but it's a high bar. So I often advise employers, to be very careful about the steps they're taking and documenting everything that they're doing.
Great. Thank you. Appreciate it. Ulrike, let's go to you next. And Ulrike, if you don't mind letting us know kind of how the vaccination rollout is going in Germany. We all know that Germany is #1 in many things related
to pretty slow when it comes to vaccination. So I was just discussing this with Jessica. I think we haven't even reached 20% of the population to have received the first shot. So we are slowly gathering speed, but it's a slow process. And interestingly enough, it works quite the other way around with COVID testing and compulsory vaccination in Germany, because it's the absolute exception that will allow you to request vaccination, which is even less likable, since there's no statutory obligation to get vaccinated. And when it comes to COVID testing, as of this week, the employers are requested to provide free of charge testing once or even twice a week to each employee, but there's no obligation of the employees to take part in these testings. So it's up to them whether they do it. However, if it's an environment where you don't have another option, where there's no alternative, such as work from home or organization of the operation, which is allowing to keep distance and keep the employees safe, then this is the testing can be expected, as it is, for example, the case in schools, nursing homes and other institutions which do have no alternatives than testing the employees in order to keep the infection rate under control. But when it comes to vaccination, there is definitely no compulsory obligation, and there it's the balancing of the fundamental right of physical what is it called, physical integrity, which is outweighing the interests of the employers in most cases, and therefore it will be the exemption that you can request the employees to be vaccinated in order to continue working. And we will see how this develops, but I'm interested to see how the rest of the European countries deal with it. I think it's pretty much the same in each European country, in contrast to the US.
Ulrike, is a difference recognized between healthcare employers like hospitals and
Yes.
like a car factory, for example, as far as one having more of a justification to require testing or vaccination?
Yes, because when the employee objects to being vaccinated, and this is the only option in order to secure the safety of the co-workers or the clients or the patients, then there will be a balancing towards the weighing of the arguments will be towards the vaccination rather than to protect the integrity of the employee. And therefore, in such cases, it could be that, yes, you can request the employee to be vaccinated. And if he then refuses and it's against all good arguments, then it might result in a termination for behavioral cause. But we haven't seen these cases yet. And I don't know whether you have the same number of corona demonstrations where large groups and numbers of people do still neglect the existence of coronavirus, and therefore I think it will be a careful balancing of how far you go. And rather seek other options of employment for these kind of employees that strictly reject being vaccinated.
Ulrike,
it's also a political, it's not only a legal issue, it's a political issue as well.
Interesting. So Timm referred to OHSA, which is in the United States, it's the Occupational Safety and Health Administration. And it enforces the Occupational Safety and Health Act, which, among other things, requires employers to provide a safe working environment for employees. Is there a similar statutory requirement in Germany? I would expect there is.
Yes, it is. And this is strictly fine and sanctions if you as the employer do not comply with those regularly updated requirements to keep the workplace safe, then you are heavily fined, and therefore you are best advised as an employer to follow exactly what is required and even do a little more than what it is expected in order not to run any risk there.
Thank you, Ulrike. Jessica, let's turn to you. In Sweden, how is the vaccine rollout going? And is it okay for an employer to require an employee to be tested for COVID before coming to work? And is it okay for an employer to require an employee to be vaccinated against COVID before coming to work?
Yes, thank you. It would be almost like in Germany in several cases again. The rollout of the vaccines it's going pretty slow, I would say. And I think it's all through the EU Union that it's slow. I think we've vaccinated around 20%, just like in Germany. And also, like in Germany, it's a no-go when it comes to demanding both having a COVID test and having a vaccine. But it's not, there are exemptions, of course, due to the field of the business, of course. And if you want to have that kind of a policy, you will always have to negotiate that policy with the unions and agree in Britain in a written CLA to be able to have that kind of policy. But in most places, you would the unions, they will not agree on such policies. And in a hospital, as an example, if a nurse says, no, I do not want to have a COVID test and I do not want to have a vaccine, they would normally get redeployed for a while at the hospital. So the integrity and privacy issues in Sweden, they are very strict in Maine.
So I've learned something new and surprising from both you and Ulrike on that point. In the United States and Canada, it is certainly permissible, if I understand it correctly, to require testing as a way to control the spread of the disease and avoid outbreaks at work. Thank you. So now fill us in, please, Girija, on the situation in India on these two topics.
So on the COVID testing, this depends on the states on whether they insist on the testing or not. It's not really governed by a central statute. So for example, in Maharashtra, where Mumbai is located, we have two separate categories of people who can go out to work presently. They are the essential services and the exempt services. There are certain binding advisories which have been issued by the state government, which require that the employees should have a COVID negative report, and this needs to be updated every 15 days. Therefore, in the event of this not being adhered to, the employers face a penalty. Therefore, to ensure that the employees are put through a COVID testing is essential. And I guess it's also a way in which the government can actually control the spread of the disease itself. Therefore, for testing, yes. So far as the vaccination is concerned, given our huge population of more than 1.3 billion, we do not believe we'll be able to cover the entire population in the next 1, 2, or even 3 years, right? So far, we've been able to cover just about 1% of the population, and that too for the first shot. So the second shot is still some time away. So that's number one. And secondly, it's not mandatory for people to actually take the vaccine. And the vaccine rollout itself has been in a phased manner. So initially, it was open to people who are over 60 years of age and the health workers. It was then extended to people who are above 45 years of age. Now, from the 1st of May, they're going to make this available for people who are above 18 years of age. But given our sheer size of population, we do not believe it's going to at all be feasible to have our entire population vaccinated before they can get back to work.
Okay, thank you. Let's move on now. And Timm, if there's anything else you wanted to add on the vaccination issue, please feel free to. But would you also address if it is permissible in your jurisdiction to require employees to come back to work as opposed to continuing to work from home?
That's the million-dollar question. We have had a lot of clients call and contact us regarding that issue. And again, as an at-will employee, an employer can require the terms and conditions, set the terms and conditions of employment. The issue is going to become, once again, if there are any type of exceptions to a disability, a medical condition. A lot of people are utilizing stress-related issues and regarding not coming back to work. But generally, the advice that we have provided, at least I have provided my clientele, is that if in fact you're following CDC guidelines and OHSA guidelines, and the CDC for those is the Centers of Disease Control, OHSA is the Occupational Safety and Health Administration, and they have implemented guidelines for employers, social distancing, mask, sanitary issues. There's a whole litany of those. And if you are, partitions, and if the advice is if you are following those guidelines and otherwise providing a safe and healthy work environment, then you can require employees to come back. Now, that is a limited number of people. Most people in the United States are still shut down. There's still a lot of remote working. So you always get the question is, if I can work from remote, then can I just continue to work from remote? So a lot of times, especially if there's a health condition or medical condition in play, and as I said, a lot of people are utilizing stress related issues and I guess just fear of coming back into the workplace, anxiety type of conditions that they're utilizing, trying to use as an opportunity to stay at home and work. So there are those situations, sort of like what we heard earlier. Is it a bona fide occupational qualification? Is it really necessary for individuals to work in the workplace as opposed to remote? And that argument is becoming more and more attenuated the longer that we have remote working. So so again, generally yes, but the devil's in the details. There are a lot of nuances to the general rule, and we obviously ask our clients to give us a call and work through individualized issues, because they do become a very individualized issue. But generally, most of the workplaces in the United States are still shut down. It's my understanding that most employers are looking not to remain shut down, looking into 2022. So we believe we're going to be probably remote working through the rest of this calendar year, even with the vaccinations and everything else. So.
Thank you, Tim. Laura, is it the same way in Alberta and Canada in general that most people are still working from home? And if an employer wants its employees to come back, can it require that they do so?
The lawyer answer is it depends. The short answer is generally yes. Employers in Canada generally have the right to dictate when and where their employees work. But however, because of COVID, I mean, if you look at downtown Calgary, all our office towers are pretty much emptied out. Everybody's working from home. Our government, and that's at the provincial level, and it's happened at, you know, healthcare is the responsibility of each individual province in Canada, and we have 10 provinces, so it'll vary somewhat. But I can speak to specifically Alberta. Our government has a directive out right now that actually says that everybody who can must work from home unless they are required to be there by their employer. So that takes the decision somewhat out of the hands of the employer. And I get the sense that most employers, many of the ones that I'm dealing with, where they can have people work remotely, it's easier to do that, and you know, less chance of having an outbreak in your office, that kind of thing. And one thing that has popped up, that in addition to people seeking accommodation to work from home, which again, if there's, you know, a valid medical reason or a stress related condition, again, though it has to be higher than just normal anxiety about COVID, like an employee saying, I don't want to ride the bus to work, is not likely to be a valid reason. But if there's a true anxiety, you know, disorder, then that's a disability that would have to be accommodated. But an issue that's cropped up big time, and it's probably a kind of across the board, is issues with respect to childcare. And in Canada, you have a duty to accommodate an employee who has childcare difficulties. And so if someone needs to work from home because, you know, the schools have shut down and you have young children at home and you don't have childcare, then an employer, again, up to the point of undue hardship, has a duty to accommodate an employee for that. So, you know, again, short answer is yes, but then, you know, subject to public health guidelines and directives from the government that take the choice away from the employer. But also to Tim's point as well, employers must be following occupational health and safety guidelines. And in Alberta, a few months ago, they required that all workplaces have COVID plans. And if you get inspected anytime by OHS, that you can present the plan, show what you're doing in your workplace to slow or to prevent the spread of COVID. And so again, if you're an employer and you're doing all of that and you're meeting those requirements and even exceeding them, an employee who would just rather work from home is probably not going to get their way if their employer does need them in the office or at the work site.
Can I
Thank you.
add one thing?
Yeah.
I'd be remiss if I didn't. There are certain local jurisdictions, state and local governments that have issued shutdown orders to which, unless you're, and there's a list of various categories of essential workers. And in those jurisdictions, if there is a shutdown order, you cannot require them to come to work. So a lot of those have been lifted lately. But there are still out west, California, and some on the East Coast, there are various jurisdictions that have placed, cities and counties that have placed orders in place to which you cannot require people to come to work. So my answer was more of a generalized answer, but as Laura said, there are specific it's very fact specific where you're living and what order is in place in that locale.
Right. Thank you, Tim. And yeah, for the benefit of our attendees, I'm also in the United States, but I'm in the Southeast. Tim is in the Midwest. And in my part of the country, just about everybody has gone back to work. Ulrike, let's turn to Germany. Is there a difference between, say, people who work on an assembly line where they can't do their job at home? Can they be required to come back versus somebody in an office who can work out of their living room?
If it weren't for the health and safety restrictions, then the employer has the right to determine the place of work. However, with the hard or strict shutdown that we are under, there is only if there's compelling operational reasons to the contrary, the option to request the employees to work in the office. So it's similar to what was said before. So we are on the same wavelengths as with the US and Canada in this regard. But this is only for as long as this strict or shutdown order is in place, which is only until the end of April. Wait and see until the prolongation comes, but following the experience with work from home, it will definitely change the working environment in the future. And I think that is one of the next questions as to whether an employee can request to work from home even beyond COVID restrictions, which will most likely be the case once you have shown as an employer that, yes, you are perfectly able to organize work from home in these circumstances. So I think this covered most of what what was discussed earlier.
So how is Germany able to keep up its manufacturing output the way it does if employers can't require employees to come back? well,
that would probably be compelling operational reasons. So if you have hospitals and where you do have to do service at the site, well, that is a compelling reason, but not for the general office work, which is easily or allegedly easily to be done from home, and that you're not technically equipped doesn't count as a reason, as a compelling reason. So you, as an employer, have to make the arrangements necessary in order to be able to do and allow work from home. But no, I mean, car factories, all manufacturing sites do have to work on site, so that is different. Schools. But schools are even requested to do distance learning, so it doesn't even apply for schools or kindergartens. They have to also work from home with distance learning.
Thank you. Jessica, tell us in Sweden, to what extent can employers require employees to come back to work in like a manufacturing setting versus the healthcare setting versus a office setting?
Well, in Sweden, we haven't had any lockdowns. Our government doesn't work that way. So they come with recommendations. So this issue is up to the employer mainly. The employer tells you where to work, and you have to work where you're told to work. But of course, if you have medical reasons not to work at the office and the employer needs you at the office, then I would say that you have to have a doctor's certificate and you need to be on a sick leave, and the employer would take a deputy, a substitute, to the workplace and solve the issue that way. So that's the main answer to this question.
Great, thank you.
Mm-hmm.
And Girija, how about for India?
In India, it's pretty much like what Timm and the others mentioned. So it would depend primarily on the health and safety regulations that are in force. So where there are lockdown restrictions, most of the private employers would keep their organizations closed unless there is a manufacturing activity where, again, then it depends on how much percentage of people can come into work so as to maintain social distancing whilst at the workplace. So when we've had lockdowns, even in factories, there have been restrictions in terms of 30% or 50% of the workforce being allowed to go into work at any point in time. But so far as essential services are concerned, they've been working pretty much round the clock and round the year. But again, for banks and financial institutions, there are local caps like 30% or 50%, depending on the severity of the spread in those local jurisdictions. So it's pretty much like what my colleagues mentioned from the US and Germany and Canada.
Thank you. So Timm, we'll come back to you for one more round of questions. And this is kind of the other side of the coin of the last question. Can an employer require that some employees who want to come back to work stay home because of any risk that they might pose to others in the workplace?
I'm assuming if you require someone to work remotely, again, the employers can set the terms and conditions of employment and direct people where they want to work. Generally, the question is going to be: are they continuing to work remotely? Or are you placing them on a layoff, like an indefinite leave of absence, if they don't, with or without pay, becomes really the issue. So I would say it really it's dependent upon the circumstances of that particular situation. But again, generally, the flip side of that same coin is that an employer can set terms and conditions, absent a contract that says otherwise, and they can require the person to work remotely, and vice versa. To my point, if in fact that they need to lay someone off, we've had a lot of furloughs and layoffs, then they can also just reduce their workforce as well, if economically if necessary. Does that answer your question?
Yeah. I mean, what I have in mind is, say you have an employee who is, has recently gone through chemotherapy, or who is older, and they want to come back to the office, and the employer is letting anybody who wants to come back. Can the employer say to that employee, without violating discrimination laws, that no, we don't want you to come in, we just want you to keep working from home?
That would go to my motto: no good deed goes unpunished. Because I would think that we're really kind of getting into the American Disabilities Act, and under the American Disabilities Act in the United States, if you regard someone as disabled, even though they may not be disabled, it creates an issue of liability. So I always advise the clients, you have to manage your workforce without regard to, almost blind. And if they're not having performance-related issues and not having issues, it's not the employer's responsibility to make sure that the person is recovering properly from their chemotherapy. So my recommendation in that situation would be is do not get in the middle of an employee's relationship with their physician. If the physician thinks it's okay for them to work and you don't have any reason to believe otherwise, other than you think it'd be a nice thing, you don't, I would recommend you do the company not go in that direction. Stay out of their healthcare direct decisions.
So Laura, let's go to Canada for that same question.
In a similar vein to what Timm said, generally, you know, an employer is not entitled to know health conditions or things like that of employees unless, you know, well, even then, even if it's impacting their work, but as a general rule, you know, to tell an employee, well, you're 70 plus and I think that you're high risk, you can't come to the office. I think you could run into all kinds of discrimination issues and accommodation issues. I mean, usually you would expect it would be the other way around. If someone had a reason, a medical reason that they couldn't be in the office, that, you know, they would, it's their responsibility to come to their employer and seek accommodation. And that's usually done in conjunction with getting a letter from their physician that says what they can and can't do. You're not entitled again to the diagnosis, but you are entitled to know what the person can do and cannot do. So I think, as Timm said, I think it would be a bit of a minefield to be picking and choosing who is staying at home based on what the employer thinks is a valid reason, because most likely you'll probably run into discriminatory, potentially discriminatory conduct.
Thank you. Ulrike?
I think it would be similar to what Laura and Timm have been saying. However, I think that you need to then, if you want to make this employee stay at home, you will have to demonstrate that you cannot accommodate or change the operation to a degree that you can keep this employee safe. And probably the hurdles would be relatively high in what can be expected from you. So you would have to probably offer him a single workplace. You would have to arrange for him to be working in an environment at the company where he is best protected from infection. And only if this is not possible, probably you could justify to request him staying at home. But other than what Timm has been saying, if you have agreed to the workplace of the site in your contract, then you cannot unilaterally change this afterwards. So if you change the workplace, meaning that you want to have him alternatively work at home or only solely work at home, then it needs the consent of the employee. So you cannot determine unilaterally, unless the contract allows you to send this employee on home office or working from home in the future.
Ulrike, you reference a contract. In Germany, does every employee have their own contract of employment? Timm mentioned that in the United States, we don't have that. We have the concept of employment at will. Or are you referring to like a labor management contract?
No, it's the employment contract which needs to be in writing, because each employee can request to have every major, although it is valid to have an oral agreement, but each employee can request to have a written employment contract which is containing all the major terms of employment. So yes, and there's standardized contracts, yes, but it is an individual contract in each case.
Thank you. Very interesting. Jessica, what's the situation in Sweden in this regard?
Well, the employer, of course, needs to treat all employees the same way. And I mean, if you start pointing some people out due to age, or if they are sick or overweighted or something, that's a high risk, I would say. So it's better if you have an employee that you are concerned with, then it's better, as Ulrike said, to make the environment safe at work. For example, with your own room, if you don't have that normally or such. So yeah, the employer decides, but it's risky to point people out saying that you cannot come to work due to this or that.
Thank you.
Mhm.
Girija?
It would depend on a case-to-case basis, and primarily driven by your employment contract. So in the event that the employer has the right to dictate where an employee needs to work from, then it would be permissible. But I agree with what Jessica just mentioned. If you're going to basically, implement something like this on a discriminatory manner, then I think the employer would run into difficulties.